Hi everyone, welcome to Africa Lesson Edition. Nnamdi Kanu Odi. Nnamdi Kanu was
South
arrested
Africa, Kenya,
because they have
for
been in
breaking the
custody no one
rules.
here for himself from his lawyer.
Solicitor, yeah.
So the lawyer he all reveal everything what happened. So after they must arrested him, they charged many criminal law against him. The lawyer have been working on it to ensure that the man is free, just like a free man. Anyway, they are not free yet. So this man is working seriously to ensure the man is free. He have not been convicted yet. He just facing trial. Subscribe and follow me on social media handle like and subscribe please.
Frivolous or vexatious. The court will not even want us to move it, and he tried to even prevent us from moving the application. The court said, you can't do that. This application is before me. It was filed since 2019, but that application constitutes the very fulcrum, the very substratum, the very linchpin of the entire criminal charge and criminal proceedings against Nnamdi Kanu. He is being tried here on certain counts, and the court continuously refused to grant him bail on the ground that the earlier bail granted to him, he jumped it. That application shows that Section 15 of the Extradition Act must come into play, which is that Nnamdi Kanu left Nigeria involuntarily when they were about to kill him and found himself abroad, before he was renditioned back forcefully in a most gruesome manner under torture on the 26th of June, 2021. That application shows from exhibits MNK1 to MNK8 the circumstances under which he escaped from Nigeria, not jumping bail. Exhibit MNK1, for example, is an affidavit he deposed to in the Holy See in Israel, where he gave facts as to how he found himself there. This is because in September 2017, I think precisely on the 14th of September 2017, Nnamdi Kanu was with his father, His Royal Majesty, the traditional ruler of Afaruku, Ibeku, Umuahia, Abia State, when the military invaded their house in the name of Operation Python Dance. I haven't seen Operation Python Dance at Sambisa Forest, dance at Chibok Forest, dance in Niger State, dance in Maiduguri, dance in Kaduna. I have not seen, but Operation Python Dance went to a peaceful home inhabited by a traditional ruler, invaded it and mauled down 28 Nigerians, 28 innocent Nigerians in cold blood, gruesomely, in a most torturous and murderous manner. They did nothing wrong. Nnamdi Kanu, by the whiskers, like the cat with 9 lives, proverbially, he was able to escape. Then you say that person jumped bail. And it is based on that so-called jumping bail that even some of the counts they have tried to amend are still coming up, and all their opposition to bail application, contrary to Section 36 of the Constitution, contrary to the presumption of innocence on the part of every accused person, since our criminal justice system is Anglo-Saxon based, presumption of innocence, and not presumption of guilt, which is the French model, which is accusatorial, which is inquisitorial. The Anglo-Saxon one is inquisitorial. Everything they have been doing is based on that. Today, the prosecution for the 7th time came forward. They wanted to again amend their charge. By the grace of God, last time, we had objected to the 15-count charge has been puerile, has been unsustainable, has been incapable of granting the court jurisdiction. The court heard us loud and clear. During the last adjournment date, the court struck out 8 of the 15-count charge, leaving only 7. He said to them to lick their wounds, and come back quietly today for a trial. Yesterday, at 2:32 p.m., less than 24 hours to the hearing of today, they came back again with a so-called proposed amended charge. Amended charge number 7. And I told the court, you cannot carry out trial by ambush. This is the 7th time you are doing this. You are federal government. You have all the equipment, all the implements, all the facilities at your disposal. How come you cannot prosecute a simple case like this? That each time we are coming to court, a day before the court, you will dump on us. You saw the huge bundles. Each of them is as fat as a portmanteau or a briefcase that they dumped on us. I, speaking honestly as a Christian, have not even looked at the amended charge, not to talk of the documents they attach, which are bundles. The client, the defendant, Nnamdi Kanu, does not even know what they are coming with. And guess what? Instead of the 7-count charge that the judge left, on their own volition, they removed one again and brought only 6 counts, no longer 7 counts. So we beat them back again with bare knuckles. They brought only 6 today. Then I told the court, the way to go about it is that if they want this count, a plea to be taken. I mean, a plea has to be taken because this is a totally new charge. They changed many of the wordings, many of the sentences, and as quickly observed by my learned friend here, because I have not even seen them. Justice is not a one-way traffic for the prosecution alone. The Supreme Court, through Justice Oputa, said it is not even a two-way traffic for the prosecution and the defendant. He said justice is a 3-way traffic. Justice for the prosecution or plaintiff, justice for the accused or defendant, and justice for the general public, members of the public, the society, which is watching, as all of you were in the court watching. Can justice be said to have been done in this case? If so, is it manifestly seen to have been done? That is the question you will be asking yourself. But what they have always done in the name of trying to prosecute the defendant is to try to overreach us, try to ambush us, and today we resisted that ambush. And again, the court saw with us. I said, you can't do this. You continue to say, under the ACJA, the prosecution can always amend his count as many times as possible, even on the date of judgment. ACJA, for God's sake, is an inferior law subject to the Constitution of the Federal Republic of Nigeria. It is a mere act of parliament. The Constitution is the ground norm, the font origo. In the hierarchy of law, it is the master law. That is why I regard the Constitution as the Oba, the Eze, and the Emir of our laws. Other laws like ACJA are inferior laws made by National Assembly. They are like ballet or district heads. So what happens when there's a conflict between these laws like ACJA and the Constitution? The Constitution tells us, Section 1, subsection 1, say this Constitution is supreme. Supreme. And then it goes on in Section 1, subsection 3 to say, if any other law is inconsistent with the provisions of the Constitution, that other law will be void to the extent of the inconsistency.